Now I'd like to take a moment and talk about some examples from the 3 different country cases that we'll be following throughout this course. I'm going to start with Tanzania. By talking about Tanzania, I'll be able to introduce some terms and concepts to you that we'll refer to again and again throughout the next 14 weeks. So Tanzania is a very interesting country. It's an important focal country for USAID and for many other donors. In Tanzania, all of the land is held in trust by the head of the state. So this means there is no freehold property in Tanzania. All property is ultimately owned by the president today. There are, however, 3 broad categories of land in Tanzania. There is general land, and this is land that's used by the state itself, the government itself. Might be used as lands that the government has placed a state-run factory on, a parastatal. The second category of land, I should say actually general land in Tanzania today, comprises between 2 and 3% of the total land in the country. So the government controls a very small fraction of the land in the country. The second major category of land in Tanzania is reserve land. Reserve land comprises about 28% of the land in the country. And these are lands that are put aside for conservation areas or for other protected areas. So the Selous National Park in Tanzania is considered to be reserve land. And then finally, the largest category of land in the country is something called village land. Approximately 70% of the lands in Tanzania are village lands, and these lands are supposed to be managed by local governance institutions that are housed at the village level. The national government can make lands available for private use, and when it does this, this is called titling the lands. The government can actually transfer land out of the village category through a process that looks a bit like expropriation into the general category. And when that transfer is complete, the government then has the authority to issue long-term leasehold rights, let's say to an investor who wants to build maybe a large agro-business in a portion of the country. That would be called a certificate of occupancy that the government would issue to this private investor. In villages themselves, villagers can apply also for long-term rights to stay in their houses, to continue to use their farming parcels. These have a different name. They're called Certificates of Customary Rights of Occupancy, CCROs. You'll hear phrases like this throughout the course. Throughout this course. Sometimes we'll be talking about people getting certificates of use rights. Sometimes we'll be talking about titling. Sometimes we'll be talking about public lands. Sometimes we'll be talking about private lands. Lands used by villagers are assigned by local authorities under various use rights recognized and organized within the village. So within a village, the local governance institution may give me a particular use right over a homestead and several parcels. They may give you use rights over some grazing land. The important thing here is that local people are making decisions about how to use their lands. You'll also find over the course of the MOOC that we'll talk a lot about the importance of being able to exclude outsiders, to create the right kinds of incentives for people to invest in and use their lands wisely. It's usually the case that villagers in Tanzania have some ability to keep outsiders out of their villages or create rules that govern how new people can come into the village. In Tanzania, the government has made a very sweeping commitment to map all village lands and to conduct land use plans for all of these villages. Land use planning is a prerequisite to issuing those CCROs I talked about just a moment ago. Doing this is an enormous challenge for the government, and many donors are now trying to assist Tanzania to achieve this goal of demarcating, that is, marking out the boundaries of village lands in the country, and then issuing customary rights of occupancy to local people as a means to improve the security that people feel over their lands. With that increased security, as you'll hear in the economic growth module, people tend to get improved incentives to invest, and that in turn raises productivity and enhances food security. Let me talk about another example now, and that is the example of Colombia. In Colombia, there are basically three types of land tenure. Public land, again, that would be land that the government is the primary controller of. Private land, and then a third category, which is communal lands. So private lands would be held individually, communal lands held by a group. Colombia is a very interesting case study because the country is so rich in natural resources and biodiversity. Culturally, it's also quite diverse, and it has a history that's been deeply colored by conflicts, by social and economic inequalities, and each one of these elements is inextricably linked to land tenure and property rights. Colombia is also a good illustration of the interaction between land tenure and property rights and justice concerns. A few examples of this: in many countries, governments have either signed on to conventions or signed into international law obligations to provide free, prior, and informed consent to indigenous peoples within their country. Sometimes the way in which FPIC consultations move forward is controversial, and this has been the case occasionally in Colombia. Colombia is also a country where special tribunals have been created to resolve post-conflict issues around land tenure and property rights. You can imagine in conflict environments, people will flee areas, settle elsewhere, and when conflict lessens or a war is over, people may move back into an area. In the meantime, other people may have moved onto their land and into their homes. So it's a very typical scenario that in a post-conflict environment, there'll be very thorny, complicated land tenure and property rights issues to address. It's also a country where another typical problem exists. There's quite a significant backlog of land disputes in courts. So thinking about the ways in which court systems can be capacitated to better address land and conflict, land tenure and property rights conflict issues may be an important component of programming if what you're trying to do is create enhanced accessibility and affordability to a court system. The third country that we'll look at over the course of the MOOC is Haiti. Haiti has, unlike Colombia, only two types of land tenure. It has public land, again that would be state lands, and private lands. Within the category of private lands, there's some tradition of family holdings. There is some group tenure, particularly for church lands, but primarily the two categories are public and private. So a really nice illustration of the importance of land tenure and broader aspects of land governance comes from Haiti, where the lack of reliable records, or in some cases any records at all, the prevalence of fraud, procedural burdens, demonstrably affected the ability of people to rebuild in the aftermath of the Haiti earthquake in 2010. It's the case that people continue to be living in camps many years after the earthquake, and in part, not entirely, but in part that's because it's been so challenging to sort out who had legitimate rights to which pieces of land in the aftermath of that earthquake. Complicating this situation, development in Haiti is slowed down or burdened by a lack of consistent planning, by regulations and enforcement of land uses and property developments that are quite burdensome for people on the ground. So again, over the next 14 weeks, we'll be touching back on these cases of Haiti, Colombia, and Tanzania to illustrate points that we're making in specific modules. So let me talk very briefly about the different categories of tenure and just some issues that you'll see typically arising around these general categories. Remember again, general categories tend to be public lands, private lands, and communal lands, to simplify. These lands oftentimes can overlap in space, by which I mean you can have a piece of public land and you can have communities or groups living on that land without formal rights to live there. In that case, you'd have an overlapping tenure system, a public tenure system, and perhaps a communal system on top of that. In addition, any one of these tenure categories can be overlaid with an array of other types of tenure. So you could imagine having a communal parcel of land. There could be another group, maybe a group of pastoralists, who hold the right to traverse the land. Maybe their migratory route cuts across that land. That's another kind of tenure that's laid on top of the major category, which would be group or communal tenure. These different types of tenure are defined by many laws, many rules, both formally and informally. And what you'll oftentimes find doing your work is that if you focus on what the law books say should be the legal and property rights situation in a country, that will not be mirrored on the ground by the de facto situation. So very typical to have a gap between what the de jure or formal legal system says are the rules and what the de facto rules really are. And it's those de facto rules that are so meaningful for so many people on the ground.